This is an appeal in the matter of Network Rail Infrastructure Ltd and Mr Karl.
Yes, Mr Clinton.
Please, your lordships, I appear in this matter with Mr Luke Wilcox, the Appellant, Network Rail Infrastructure Ltd, my learned friends, Miss Galena Ward, King's Counsel, and Mr Hugh Flanagan, the Respondent Valuation Officer. In terms of very briefly housekeeping, there's a core bundle containing the skeletons, including a supplementary skeleton for which permission was granted.
Yes.
There's the usual supplementary bundle, and then there's an additional bundle called the confidential bundle, which is an overstatement because there's simply a confidentiality order in place in relation to the certain financial information that contains material that we're going to go to.
Yes.
And then there's the bundle of authorities.
And we can deal with that simply by you referring us to it without revealing it in open court.
Indeed. And as my lords will know, this is an appeal from the decision of the Upper Tribunal dated the 12th of November 2024, entering 2 advertising hereditaments in the local rating list with effect from the 1st of April 2017, one at Victoria Station and one at Liverpool Street Station. In terms of what the case is about, very briefly, the case is about the rating treatment of advertising at operational railway stations. It arises from a decision to list 2 sample advertising rights hereditaments in the local list. And that decision marks a departure from what had hitherto been the prevailing practice for decades. In granting permission, the Upper Tribunal made some observations about the importance of the issue, and that's at page 93 of the court bundle, which I don't ask you to turn up, but they said in essence, this court hadn't looked at advertising for 30 years. There'd never been a case on the intersection between the local list and the central list, and the matter raised important points of principle with significant practical and financial implications. I make 3 observations at the outset. Firstly, this is not a case about whether to tax advertising. It is a case about how to tax advertising in accordance with the statutory scheme. The particular issue was prompted by billing authorities raising questions with the valuation officer and is being appropriately tested to see what the right legal answer is. The second observation is that the case turns, at least on the tribunal's reasoning, on a point of construction about section 64(2) of the 1988 Act. And the tribunal made that clear in terms in paragraph 36 of its decision. The meaning of let out to a person other than the occupier hasn't been tested in an advertising context. Moreover, all of the advertising cases that have come before the courts concern circumstances where there is an obvious separation between the advertising right and the host's occupation. In those cases, the separate listing of an advertising right and the rationale for a separate regime align. We say that this case arises in a different situation. The critical point is that the advertising furthers the purpose of the rateable occupier, that is Network Rail, and it's actually, as we'll see, it's deemed to be a statutory railway purpose under the scheme.
Is that relevant to the construction question under the 88 Act? Presumably, your arguments would have to hold good if it were a supermarket or any other person who wasn't a railway.
Well, yes and no. So, yes, insofar as we're dealing with section 64(2), no, insofar as we're dealing with a proper understanding of the anticipated relationship between section 64(2) and the central list regulations. So it furthers the particular purposes of Network Rail, which we do say relevantly is a railway purpose under the statutory scheme, and where there are contractual provisions which ensure that the advertising, we say, obviously have to make this good, is subservient to the operational requirements of the station. and there's no advertising case on section 64.2 that raises such issues. But the other dimension, which I foreshadowed a moment ago in the answer to my lord, is that this case raises directly the question of how the central list hereditament intersects with the separate treating of advertising rights. And we say that the tribunal got that wrong. We say they misunderstood, misconstrued the clues that the history gives them as to how it was intended that advertising rights and the central list provision work together. And that is a discrete element of the case where we say the tribunal got it wrong. So the way the grounds are structured, just to orientate the case, is that there are 4 grounds. The first ground is the point of the construction of section 64.2, and that is the meaning of let out to a person other than the occupier within the context of section 64. I make it clear at the outset, as I did below, that I accept that advertising rights are a distinct type of hereditament, and I also accept that they have special rules of deemed occupation when they exist. But I say that the use of the familiar term let out conveys the essential requirement that there must be sufficient separation from the host occupation, and that requires, at least in this case, regard to a wider range of considerations than the tribunal allowed.
Sorry, what do you mean by this case?
Well, I mean where there is a link between the purpose and where there is, I say, an obvious exercise of control over the way that the advertising interacts with the host's rateable occupation.
Because we have to construe section 64.2 as it applies to all cases.
Yes.
Not just railway areas.
Precisely. There are 2 points that's why it may be helpful to think about the 2 points. My submission is that the essence of the concept of let out is separation. In the paradigm advertising case, the separation is obvious. There's a spectrum of cases that will necessarily arise where it will be less obvious. And what the tribunal did is it avoided grappling with what let out means in the less obvious cases. And obviously I'll develop that, but just to answer directly my lord's question. So that was ground 1. Ground 2 is that the approach to the central list is wrong and inconsistent, and it doesn't function effectively. I'll obviously make that good by reference to the statutory scheme and most particularly the history. Ground 3 is the factual application of what we say the right test is. That was dealt with very shortly by the Upper Tribunal in 2 paragraphs, paragraphs 61 and 62. We've said our submission is that they got that wrong in terms of the legal effect of the agreement and took an inconsistent approach to the analysis of the terms of the agreement as opposed to its practical orientation that was inconsistent with, amongst other things, the Court of Appeal's decision in Ludgate House. But I'll come to that separately under ground 3. And then ground 4 is a point of approach. They consciously left out of account the practical issues, and we say that was wrong as a matter of statutory construction, both generally and especially in the particular circumstances of this rating provision. So that's the shape of the argument. The way I hope to take my lords through it as expeditiously as I can is in the following 6 stages. We'll deal with the facts concisely, then the current statutory framework. Then I am going to spend a short amount of time on the history. The reason I'm going to do that is I will say that it helps to understand the treatment of advertising, the treatment of the railway hereditament, and therefore the intersection between the 2 of them and how that has changed over time. Then I'll highlight the fundamental pinch points, if I can put it that way, in the Upper Tribunal's analysis and where we submit they went wrong in relation to our 4 grounds. Then I'll deal with the case law, so the extent, which I'm afraid is limited, to which the case law assists on the question of let out in an advertising context, what it says in a railway context, and also where the the Southern Railway line currently rests after the Supreme Court case in Cardtronics and the Court of Appeal case in Ludgate House. And then briefly I'll draw the threads together in the sixth stage in relation to each of my grounds.
Just before you get launched on that, have you discussed with Ms Ward allocation of time between you?
We have briefly, and the proposal is that I could have until 3 o'clock today, and that would leave sufficient time on the basis that I understand we have a day and a half allocated for the case.
And have you given consideration to everybody who's on the team sheet having a speaking part?
I understand from Ms Ward that Mr Flanagan is going to be making submissions. We've certainly given consideration of it. The current plan is that Mr Wilcox won't be participating, but we certainly have discussed that possibility.
Right. Well, as you know, we are very keen to encourage that.
Yes, indeed.
And softly be it spoken, we often find that the representations we get from the juniors are as helpful, if not more helpful, than those we get from the leading council.
I'm sure that's right. That will certainly be the case. So may I go through the six stages? I'm going to start with the facts. I'm just going to deal with the physical facts and then the facts of the agreement. And if I could take the court, first of all, to the agreed statement of facts below, which will be in the supplementary bundle behind tab 1. And starts at page 3. And then I would ask the court to go straight to paragraph 5 on page 4. The Victoria Station advertising site is shown and described in photos attached to Mr List's evidence. It's a backlit box with 2 sides used for advertising, and then its location is described. And just to go to the photographs of that further on in the bundle, at page 187, which is behind tab 11, you've got 2 views of that particular advertising site. In the top photo, you see it side on, and in the bottom photo, you see it suspended over the middle of the concourse with the red signage on it. So that is the static site at Victoria Station. And in terms of the Liverpool Street station, if I go back to the agreed statement of facts at paragraph 8, it's described there. It's a digital transvision installation. There's some discussion of its location and the way it's connected with Network Rail's electric power circuit and how it's operated in paragraph 8. And in terms of just understanding what we're discussing, if the court goes please to page 190. In the first photograph there, you'll see a tantalisingly blank digital advertising display, but that is the that is the photo. That is the digital display that's located over the concourse from Liverpool Street Station.
Yes. Are we concerned with the hereditament being those particular signs, or are we concerned with the hereditament being the right to advertise?
The argument has at all stages proceeded on the basis, which I say is the correct basis, that it is the individual rights which are hereditament.
So what do you mean by individual?
It's
the rights conferred by the agreement which we've got to construe.
In relation to each site, I would respectfully submit. So the rights.
So each site being the physical box, or
Yeah.
each site being the relevant station, or each site being the entirety of the space which is governed by the agreement.
Each site being the physical manifestation of the collective advertising rights in the agreement, which is to be individually listed.
Sorry, you're going to have to say that more slowly.
Each site
is the physical
manifestation of the advertising, the collective advertising rights under the agreement. So it is a site by site. So it's the signage. The decision to commission signage is the exercise of an advertising right, which, if this case succeeds, will be shown as an individual hereditament in the rating list. So and that's consistent with the fact that before you is only the sample right, and that's what this case seeks to establish. But
Sorry, it's my fault.
sorry,
The sample right
yes,
is what exactly?
it is the actual the actual right is the digital advertising right at Liverpool Street Station, which is described and assigned a value. So it's the individual.
It's described, sorry?
It's described in the list, and
Yeah.
a value is assigned to it. So I'm going to say the individual right, the individual site, but that's technically not quite right. It's the right in relation to the individual site, which in this case says should be listed in the local rating list.
So if the agreement would enable JC Decode to put up another digital sign in the station, but they choose not to do so, is that rateable?
No, it's not. It would have been on the construction of the statute as it was originally enacted, but as you'll show, my lord, in due course, it has to be exercised. So the case of Imperial, which we'll go to in the House of Lords, that dealt with the construction of the original Section 56 of the 1948 Act. They said it was just the right, whether or not exercised. That was reversed, and I'll go through that in the history. But it has to be exercised.
So it's the exercise of the right
Yes.
that constitutes the hereditament.
Exactly.
And it's a separate hereditament for each advertising station.
Yes, that is what is being tested. My case is that's wrong and unworkable, and the right legal analysis is this is all part of the cumulo. But what is being tested is the proposition that each exercised advertising right should be separately listed in the local rating list.
So if you look, for example, at page 188, where we have some more photographs, lower photograph is a wall at Victoria Station with 2 adverts. Would that be 2 hereditaments or 1?
That
Don't you know?
No, the logic, the only reason I'm hesitating, the logic is it would be 2 hereditaments. The only reason that I am hesitating is I was wondering whether they were going to be sent to be railway adverts and there'd be some separate treatment of those, but I don't think they are, and therefore I think the answer is yes, that would be 2 hereditaments.
Dan, it's in the schedule, isn't it?
But
It's in the schedule to the agreement,
Yeah.
the identified sites. Yeah.
What you've got in the agreement is a sort of framework which gives the concession, the terms of the concession, but presumably somewhere the parties have agreed where the what advertising is the subject of the agreement.
Yes. Would it help to show you that?
It's not at large.
No, exactly. Can I come back to that when I show you the agreement? Because yes, there is a schedule, and effectively what's being tested is the individual listing of each item line in that schedule in the rating list. So may I move on from my lord's initial question? Just for context, and in case it's helpful, the reference of this is page 48 of the supplementary bundle, but you don't necessarily need to turn it up. So there are 135 advertising sites at Liverpool Street Station and 179 at Victoria Station. And actually, just because it arises in relation to what we've just been discussing, if my lords go to page 60 of the supplementary bundle, this is the live list, so exactly as my Lord Justice Holgate indicated, presumably the parties have a live list. There is a live list under the agreement.
so sorry, could you just give me the reference again?
Page 60.
Thank you.
And the second line item in that schedule is the digital advert at Liverpool Street Station.
So your 138 will be shown somewhere in this schedule for Liverpool Street, and
Yes.
179 for Victoria.
Yes.
How does a site get into the schedule?
There's the evidence on that is that there is the maintaining of a live schedule. But can I come back to that question when we look at the agreement?
Please.
Because the answer will probably reveal itself as we go through the agreement. So that's all I'm saying about the physical facts. I was going to go on to look at the 2010 agreement, which is obviously the critical document. And that's in the confidential volume, starting at page 12. And the Lord, I'll take this as efficiently as I can, but obviously this is the critical document which to the legal construction of this document is central to certainly round 3, and will no doubt assist the court in thinking about how round 1 might work in practice.
Yeah.
So it's a railway advertising concession agreement, as you can see from the front page on page 12. There's an overview of the terms on page 13. If I could go to the recitals on page 14, just looking at the background recitals there, Network Rail has within its possession and control space at the railway stations and land adjacent to its tracks and railway stations, which is and may in due course be available as advertising space. It wishes to grant a concession to the concessionaire to manage, promote and exploit the advertising space, and then C records the skill of the concessionaire JC Deco. The definition of the advertising space, which I think is germane to my Lord Justice Holgate's question there, is the ambient advertising space and structural advertising space in each case as set out in Schedule 4 to this agreement, as may be amended from time to time in accordance with the rights set out in this agreement. So there was a master schedule at the point at which this agreement was reached, but it's a live schedule pursuant to the definition of advertising space under the agreement. Then on page 15, the definition of the...
You have to read it with the next 2 definitions as well, don't you? Ambient advertising space is 2 down, and that takes you back to ambient advertising media.
Yes. My Lord, yes. The concession, if I'm still on the definitions, page 15, the concession is defined as the advertising rights made available to the concessionaire as set out in clause 3, and obviously clause 3 is a critical clause to which we'll come. And I don't think I need to take any other definitions other than just for completeness to show you that the definition of managed statement starting on page 16 includes on page 17 Liverpool Street Station and Victoria Station. If I may then go to the operative clauses themselves. So the terms dealt with in clause 2, and it's 5 years from the 1st of September, which is the way the effective date is defined. But if my lords just note or go briefly to page 262, there was an extension of the agreement on the 29th of September 2014, and it was agreed to be extended to the 31st of March 2018. And you'll see that from page 262. So this is the operative agreement at the material date of the 1st of April 2017. Then we get to the heart of the matter, the scope of the concession granted by clause 3. So the opening words of clause 3.1, subject to the provisions of the agreement and in consideration of deciding on the fee, Network Rail grants to the concessionaire from the effective date and thereafter during the term, and subject to clause 3.3, the exclusive right to maintain, manage, promote and exploit the sale of the advertising space. So I accept on the face of it the conferring on a right to advertise, importantly qualified in 2 respects, expressly by reference to clause 3.3 and also by reference to the provisions of the agreement. The qualifier under 3.3 is at page 20, which is notwithstanding the rights, Network Rail reserves the right to install and display directory boards, lights, signage, notices, etc. 3.31 for the safe and efficient running of the railway, providing directions and assistance, etc. And such signs may provide directions or assistance by any means, including by use of the company name, trading name, brand name, or logo of the third party in question. So Network Rail can advertise people who've got, for example, W.H. Smith at Victoria Station. Network Rail could advertise their presence by virtue of clause 3.3. The ownership of the structures, 3.5, remain vested in Network Rail. Clause 4.5.
I'm sorry to be slow. You would, yeah. There's a reference somewhere to structural advertising space. I saw on them as well.
Page 18. Structure and structural advertising.
Yes. And that's on the structures available to the concessionaire. Yeah, okay, thank you.
Thank you. So I'm going to go within clause 4, the overall heading of clause 4.
Just before we move on from there, not all ambient advertising space will be structural. Is that right?
Well, in fact, one goes back to follow my Lord's question, page 14, advertising space, in fact, has two limbs to it. It's the ambient category and the structural advertising space,
Yes.
which is why I was anxious to find where that was defined, and that's on page 18 with the definition of structure as well. So there seems to be two types of
Yes,
advertising space.
I think that's right. I'm not sure anything particularly turns on that, but I will pay
Maybe.
attention to that as we go through the
Maybe,
terms.
but it looks as though ambient advertising media and therefore advertising space can be on something which isn't a separate structure and which in occupancy terms would not be designated as a separate space. It could be painted on a clock, on a wall,
I think that
something of that nature.
that would still be there would still beg the question about whether that's right, but I think that's within the definition of the term, yes, because there could be the erection of a structure and there's provision in relation to that, or not under the broad definition of the rights under this agreement.
Well, if you go back to page 14, advertising space, the first limb is ambient advertising space. The definition relates to spaces where advertising may be, spaces as opposed to structures.
Yeah.
And by reference to ambient advertising media,
Exactly.
which enables advertisements potentially to be placed on floors or on walls or on clocks.
Yeah, there's opportunities for advertising which have to be created and agreed in accordance with the agreement, but they cover advertising on a structure or otherwise. That's right, and I accept that, and that's what's provided for in the agreement.
Yeah.
In terms of clause 4 of the agreement, which is at page 20, the overall heading is adjustments to the advertising space. May I go to clause 4.5, and I'll say just to signpost this, clause 4.5 and 4.7 are central to Network Rail's arguments. So clause 4.5, subject to clause 4.6, Network Rail may by notice at any time and from time to time in its absolute discretion withdraw any advertising space. An advertising space shall be deemed to be withdrawn if Network Rail permanently disturbs or obstructs any structure, ambient advertising space or site, or to dispose of any site at any time, and except where such withdrawal or disposal takes place in connection with the removal of a managed station from the scope of the concession, then the provisions of 4.10 apply, and that's a financial adjustment to profit share, and there's no other liability in relation to that 4.5.2. So on the face of it, this clause effectively gives Network Rail, in its absolute discretion, the ability to terminate the advertising space at any time, and it covers the range of advertising spaces that my lords have identified.
So the profit share, presumably there's a formula for calculating it by reference to the income from individual advertising
Yeah, well,
facilities.
there is. I will show you where that is
Thank you.
in due course, but yes, there is. So that's 4.5, and 4.6 is a restriction, and this is relied on by the valuation officer. There's a restriction in 4.6: any advertising space which is withdrawn by Network Rail under clause 4.5 may be re-offered by Network Rail at any time with immediate effect upon notice in writing to the concessionaire that any advertising space withdrawn will not be offered to any third party during the term. Now, I accept that the effect of this agreement is to give JC&Co exclusivity in relation to advertising at the station. Network Rail could advertise under its rights under 3.3, all because it's not commissioning a third party, but you couldn't bring in another partner during the currency, even if you exercise your clause 4.5 power to withdraw. 4.7 is also a clause that's central to Network Rail's analysis. Network Rail shall be entitled at any time temporarily to disturb, remove or obstruct any structure, ambience, advertising, media or site in Network Rail's opinion, if in Network Rail's opinion it is necessary or desirable to do so, including but not limited to in connection with safety, any emergency, breach of the concessionaire of an obligation to which the concessionaire is subject, and 4.74, the operation of Network Rail's undertaking. And Network Rail shall provide as much notice as is reasonably practicable of its intention to exercise this, except in an emergency where no notice shall be required. So there's the right to temporarily remove, disrupt or obstruct the advertising, subject only to Network Rail forming the opinion that it's necessary or desirable to do so, having regard to the operation of the Network Rail's undertaking. So when Network Rail, in relation to digital advertising, decides that it wants to interrupt the advertising to communicate, for example, transport information because there has been a derailment or there's unusual delays or there's something in relation to the network which needs to be communicated, it has the right to do that through clause 4.7.
Can I just, forgive me, we didn't look at the definition of site, I don't think.
Right.
Page
Go
18.
back to page 18. So is the distinction between advertising space and a site that the site is an area of land within which the advertising space is, rather than the structure or other physical embodiment on which the advertisement is enclosed?
The sites are potential sites until there's the identification of them in accordance with the provision that I showed you earlier.
It's page 18, Dan.
Sorry?
There's a definition of sites, page 18.
Yeah, that's what we've asked. Forgive me. Yes, the definition of sites on page 18, those parts of the managed stations and those parts of the land adjacent to the track station that contain advertising space.
Well, yes, the list, which is subject to adjustment under clause 4, is a list of advertising space, not sites. I wonder whether sites is a more general term, which is parts of the station, rather than the place where the advertisement takes place.
My understanding and submission is that clause 4.5 and 4.7 are directly bearing on any advert that is being displayed.
4.5 deals both with advertising space, which can be withdrawn, and with disposal of a site.
Yes.
So that, but they may be two separate concepts.
Right.
And I just wonder whether we need to be careful in our use of language about referring to a sign as a site, when that may be not what's meant by a site in the agreement, but maybe a shorthand one would use in colloquialism.
Well,
That's the only reason I draw attention to it.
I'm ungrateful. I'm not sure I need to refine any of the submissions or not submissions, but the provisions that I've shown you. But I will.
No, all right, thank you. I just wanted to follow that through. Thank you.
Of course. May I just continue on clause 4? Clause 4.8 is Network Rail's reserves the right to close any managed statement or track at any time in its discretion for operational reasons. That's not a clause that I particularly rely on, because that's replicated in some of the other case law, and in itself is not of particular significance. If I go to clause 6, just to continue the journey through the agreement, the duties of the concessionaire are set out in clause 6, and that includes complying with relevant obligations of the agreement, complying with standards, that's 6.2 and 6.3. There's various other provisions, including 6.16 on page 24, which is a limited form of price control. So the concessionaire shall not aggregate any advertising space with any of its other advertising sites in a manner whereby effectively there's bulk discounting. Clause 7, on page 25, is the operative clause for certain key performance indicators which appear in the schedule to agreements.
Sorry, that's clause.
Clause 7 on page 25.
Thank you.
And clause 8 is the operative clause in relation to the financial arrangements and the profit sharing. So I draw attention to that. The figures are set out there. I'm not going to speak to them for obvious reasons, but the mechanism of the profit sharing arrangements is set out in clause 8, and there are some detailed provisions in relation to that. I just, if we go to page 29, just two specific points to draw attention to. 8.18, not relied on by either party, but I just signal it for transparency, provision in relation to rates. So that's dealt with as a matter of contractual entitlements at 8.18, and 8.21, the concessionaire will not, without prior written agreement of Network Rail, enter any agreement with any person for supply of goods or services where the consideration for such supply is provision of advertising space, so a form of control in terms of the contracting JCT, albeit a limited form of control. Over the page.
Well, just before we leave
yes.
clause 8, without referring to any confidential details, the formula, there's a minimum payment, and then the formula is in 8.6, isn't it? There's a share which is applied to net revenue less direct costs.
Yes.
And net revenue is a defined term on page 17.
I'm sure that's right. Let me.
The impression I get is it's a cumulative sum which is made up of the relevant revenue from each of the spaces.
That's right. So there's a profit sharing formula.
Yeah, which we didn't go into.
No.
But so when, for example, as you were pointing out earlier on, a particular space is withdrawn, that results in adjustment to the money paid.
It goes into the mix.
Because what happens under this concession arrangement is that the revenue is calculated by reference to each and every space, whether there's 179 or 138 or whatever.
No, that's absolutely right. There's an amalgamation. That's absolutely right. The spaces are defined both in the schedule and by a mechanism within that. In terms of financial provision, it's not it is dealt with on a site by site in the sense that if a site is taken out, there is an
Space by
adjustment.
space.
There is an adjustment to a formula.
Subject possibly to some thresholds in 4.10.
So, but for my part, let me make it clear insofar as it assists to do so. I fully accept that advertising at railway stations is valuable both to JC Deco and to Network Rail. My submission is that proposition in itself doesn't answer the issue in the case. The issue in the case turns on proper construction of, I would say, the control and supervision of the advertising under the terms of this agreement. Obviously, I need to make a number of legal points to get to that stage of the analysis.
Okay, can I just go back? You said that if a space is withdrawn, there's an adjustment to the formula.
Yes.
Is there a particular provision to that?
I think that was a reference to what I had referred to as 410. So and that's a provision where if you withdraw the space permanently, it's subject to it's on page 21. It's subject to the provisions of 410, and that was the provision I had in mind when I talked about the adjustments.
There's something called.
Is it
Oh, yeah, sorry.
just adjustment to minimum payment?
That's what I was wondering, because if the net revenue goes down, the profit show, you don't need to adjust the formula, it just works its way through. But this adjusts the minimum payment if there's a sufficiently large.
Right. That seems to be right as a refinement. I just wanted I drew attention to 410 because I rely specifically on 4.5 and it's subject to 4.10. So there is the ability to translate a financial consequence from the exercise of clause 4.5. It may well be entirely academic in many cases where that exercise is on a small scale.
But subject appears from 4.10.2 to it having to amount to more than a particular percentage. So you've got to have that percentage of withdrawn space before there's any adjustment at all.
Yes. So the upshot of that is
percentage by revenue.
So the upshot of that is in the ordinary course of events there is the ability to withdraw specific site/stroke spaces, and there isn't likely to be any financial adjustment from that.
So to the extent it works its way through to the profit share. But not to the minimum payment.
Yes, yes. So I'm sorry if I'm not going over this as comprehensively as would assist my lords. I was going to next go, if I may, to when I've shown clause 11, which is on page 31, which is relied upon by the valuation officer, and this is the obligation of the concessionaire to maintain all structures and fixings for ambulance advertising. So that is something which JC Deco exercise the responsibility for maintaining the sites once they come into existence. And my lords, I would next go to there's provisions in clause 12 for access to Network Rail's premises, which I just note they're subject to a number of clauses, including 19.2, which is one I'm going to take the call to in a few moments. But I don't specifically take time on those now. Clause 16 is again obligations on the concessionaire in relation to complying with relevant standards and advertising codes of practice. My lords will find that on page 33. And clause 17.1 on page 34 the concessionaire must not enter into an agreement with any advertiser or agents or any other person that restricts or negates the rights and powers of Network Rail under this agreement, and for the avoidance of doubt, where Network Rail exerts its rights under clause 4.3, 4.5 and 4.7 and 4.8 of this agreement, and provide that Network Rail is given the concession, provided that Network Rail is given the concessionaire reasonable notice in writing of the intention to dispose of the site and withdraw the advertising space, the concessionaire shall indemnify and keep indemnified Network Rail against all liabilities. The effect of that, I would respectfully submit, is to embed the rights under clause 4.5 and 4.7 as central to the agreement, making it clear that the responsibility for communicating that rests on JC&Co, and there's no liability for Network Rail in relation to exercising those particular provisions. Clause 18 on page 34 is Network Rail's own allocation of advertising, not something that I rely on as significant to the issues in the case. But I will come back to it in ground 3 because it's indicative of that there is an allowance, so they can do some own client advertising or actually do things like charitable giving under this clause, but that's a subsidiary element of the overall advertising, but it's specifically provided for by an allocation under clause 18. And then at page 36, I mentioned a few moments ago, clause 19.2, and that is a restriction on access in pretty wide terms. So Network Rail may, in its absolute discretion, refuse access to its premises at any time, and from time to time to any person employed by the concessionaire, its agents and subcontractors, or any advertiser. And then, just for completeness, clauses 20 and 21 make provision for the sharing of financial information by JC&Co to Network Rail, and for review meetings and reporting on financial progress. So Lords, that's the shape of the agreement. I think I've covered all the clauses that have been relied upon in the skeleton arguments on both sides in that survey. May I, before I move on to the law, may I make the following brief observations? As I've already said, I accept that advertising is valuable, and this is an agreement for which JC&Co and Network Rail each derive considerable commercial benefit from profit sharing arrangements. I say the overall context is that Network Rail wants to have advertising at its stations, amongst other things, to generate revenue from the railway. JC&Co have the expertise. Network Rail contract with them to deliver the advertising. The way that the advertising operates is closely controlled by Network Rail, and in particular there are provisions which ensure that the advertising operates in a way that is subservient to the operational needs of the railway. I especially rely on clause 4.5 and 4.7 in that respect, where the powers of termination and or to cut across the advertising are expressed either in terms of absolute discretion or in terms of the desirability for the benefit of, amongst other things, the operation of the station, and those powers are exercisable during the currency of the agreement, and that's a point that I say is legally significant, which I'll come back to. So, Lords, that's the facts. May I move on to the statutory scheme, part 2 of my submission?
Can I just ask about the costs, because you touched on the repairing obligation a moment ago.
Yes.
As in the profit share formula, costs are not individually assessed. There's a straight percentage which can be applied to the revenue, which can be taken into account for cost.
Well, I don't have a...
But that's we have that in...
that's what the agreement provides for. Forgive me,
8.6 and 8 point, yes, thereabouts. 8.6 direct costs.
Yes, I don't believe that there. I don't believe that there was any evidence on that point in the tribunal alone.
But just looking at the face of the agreement, the revenue share is the revenue less the direct costs as defined, which is expressed as a percentage. So the risk as to costs is something borne by Deco.
That I believe that is right, I would guess. I believe that is right.
When you say that Network Rail wants to have advertising to generate revenue from the railway,
Yes.
we're looking at railway, is that any more than wanting to generate revenue from the fact that it has the stations? They are an opportunity to advertise to the footfall in the stations in the same way as would be the case of anybody in other public buildings.
So,
Or is there something about the operation of the railway itself which is a purpose which is served by advertising in the stations?
well, there was a small amount of evidence on that point in the court below that there has always been a connection, that advertising has always been part of the offer for the railways. I don't have any direct answer to my lord, but the submission I make is that when we look at the way in which this has been dealt with through the rating provisions and through the definition of railway purposes, the inference which arises, at least historically, is that it was seen as part of the funding mechanism for a national railway, for there to be advertising revenue as something which was inherent in the operation of a railway. Now, I can only make that good by inference rather than by a direct source, but that I do make that broad proposition as an explanation for why advertising has been dealt with in the way that it has. But if I could then just also, independently of that point, put forward this proposition, the distinction that I would seek to draw, or the parallel that I would seek to draw, is that the Network Rails, irrespective of what I've just said about the specific statutory provision, Network Rails is using advertising at its stations as a part of what I would call its railway purpose. I'll have to make that good.
But that's what I'm just trying to understand, and just for my own purposes, see whether that is different in nature from, and I quite understand the statutory context and so on, but just whether that is different in nature from the purpose of letting out advertising in many other forms of public building. It's a fundraiser and it's an opportunity to raise funds because there is footfall within the building, which is regarded as valuable to those who want to advertise.
Yes.
But beyond that, does it have any particular connection with the business of running railways as opposed to the business of running supermarkets or matters of that nature?
Or a shopping centre.
Or a shopping centre.
Well,
that's what I'm just trying to tease
so
out.
the submission that I do make is that there is a parallel between, in the Cardtronics case, which is not an advertising case, and it's said against me that that's irrelevant because it's about a different type of hereditament. It's about the placement of ATMs within supermarkets. What was critical to the Supreme Court's analysis in that case was that the provision of the ATM machine furthered the retail purpose of the supermarket.
Well, I can understand that because if people were paying in cash as they used to, the ability to obtain cash at the site might directly generate more sales.
Yes.
That's not necessarily comparable to what we're talking about in terms of advertising.
Sometimes people go to an ATM which is in a supermarket because they want cash, and while they're there they might as well buy something. So there was some suggestion, I think, that providing ATMs directly increased your sales. But people don't go to stations to see adverts, they go to stations to catch a train.
Well, my lords, the parallel I do make is I do make the parallel with Cardtronics. I hear the points that my lords make. Now I'll come back to that in submissions when I show the historic context, because I do say that the provisions of the central that are still on the central list do, in this context, suggest that the provision of advertisements at stations are to be treated as a railway purpose, and I do therefore rely on that. But it may be that if my lords aren't with me on that, then I don't have a strong analogy with Cardtronics, but that is a plank of my argument to draw a parallel with Cardtronics.
Thank you.
So again, may I then go to the statutory framework? So part 2 is the current provisions, and I'll be spending some time on the bundle of authorities. may I go first, please, to page 4 of the Local Authorities.
For
Page 4. And I'm going to take my lords through the current operative statutory scheme. By current, just to be precise, the relevant date is the 1st of April 2017. So we're in the Local Government Finance Act of 1988, which is the operative rating legislation. Section 41 contains a duty on the valuation officer to compile and maintain a local rating list. That's on page 4. And then if we go over the page to page 7, there is section 42, which is the contents of the local rating list. And 42.1, just invite attention to, so that each hereditament which fulfils the following statutory conditions are in the local list. And just invite attention to B and D. So it's a relevant non-domestic hereditament, and we'll see what that means in a few moments. And D, it is not a hereditament which must be shown for the day in the central non-domestic rating list. So the local list consists of relevant hereditaments that aren't properly shown in the central list. So not conclusive in itself, but this part of the statutory scheme indicates that you've got to apply your mind to whether something should be in the central list before you put it in the local list. The central list is section 52, so I'm now on page 9 of the bundle of authorities, and section 52 is effectively the enabling provision for the compilation of a central rating list. And if I may then go over to section 53, which the court will find at page 12. Now, this is titled in the Westlaw extract, Contents of the Central Rating List for Wales. That is incorrect. It's an overzealous annotation because there is a provision that's as yet to come into force which puts it on a different basis for England, but this is the operative provision for England as well as Wales. So I apologise if you're misled by the title there, but my submissions proceed on the basis this is the operative provision for England. So the purpose of the central list there is with a view to securing the central rating, rather curious phrase, en bloc of certain hereditaments, regulations may be made, and it then talks in subsection 2 of amalgamation. So the relevant statutory purpose of the central list is the amalgamation of hereditaments. One must infer because it is convenient to do it in that way.
What happens to such rates? Do they go to central government or are they distributed amongst the local
That's
authorities?
That's the, my lord has perceptively identified the economic motivation for this matter being in court. The central list goes largely to central government. The local list nowadays has an element of rate retention and therefore benefits the local authorities. And so that's why this case is financially significant to the billing authorities, because if the adverts are displayed in the local list, there's rate retention, and if they're in the central list, there isn't. There's a central formula.
is it the central valuation officer who's responsible for collecting the rates charged on the central list?
I don't think he's responsible for collecting rates.
There must be somebody responsible. Anyway,
But
but
can I?
on the local side,
Yes.
it's the individual billing authorities up and down the country.
Yes, and as my lord knows, but I'd say simply for the benefit of the doubt, the scheme provides that actually the 1988 scheme, one of its central features is the separation of the listing of property and the collection of rates. The listing is centrally the valuation officer is responsible. The collection is the business of the local authority. May I part my lord's question, which I'm afraid I don't immediately know the answer to in relation to the central list, but we'll find that out, and I'm sure Miss Ward's clients will be able to answer that very easily.
And was central listing new in 1988?
My lord, it was a feature of, yes, I'm going to spend some time on the railway, but the short answer is that is correct.
Well, never mind railways, because it doesn't, central listing doesn't just apply to railways.
It
does
doesn't.
But central listing as a whole, was it new in
I
1988
don't
or
think
not?
it was a new, so it was a new concept for it to be dealt with by a central list. It wasn't a new concept for there to be the aggregation of hereditaments.
Thank you.
Well, that was done in 1930 in relation to railways, and for nationalised industries, it was done frequently by prescription through statutory instruments.
Yes, and then the actual critical issue in this case at round 2 is how a pre-existing situation is implemented in a situation where advertising stays in the primary legislation and the central list moves from primary legislation to secondary legislation, and we will come to that when I deal with the history. So that's all I would say about section 53. May we then go to section 64, which is page 14 of the Governing Authorities.
But the principle I suppose you get from 53(1) is you can only aggregate something which would otherwise be a hereditament.
Yes, that must be right.
It just lumps them all together.
Yes.
Hmm.
I mean, where that takes everybody, we'll have to come back to.
Yeah.
But that's the premise on which it is that there is a policy in favour of amalgamating hereditaments for the convenient connection, is the way I put it.
And not only do they have to be hereditaments to be amalgamated, they also have to be in the occupation of the same person.
We're going to have to, my lord, that's right. We're going to have to think. I mean, my lords will have to think, and I'm going to have to make submissions about how that works under the statutory scheme in relation to advertising rights and how that is drafted. And that is a critical issue between us on how you approach what we're about to see, which is Regulation 6 of the Central List regulations. But the answer to my lord's question is yes.
So if you leave aside advertising rights, which are of a particular type, with ordinary hereditaments, a railway will be in the central list for all the railway hereditaments occupied by the railway, not for bits of stations occupied by other people. And that's the southern case.
That's right, but you get to that conclusion through an application of Regulation 6 rather than before you think about Regulation 6, and I'll show why that is. But that is, I think, an important difference between the parties in the case, because that's what Regulation 6 is designed to flush out, what is within or without the railway hereditaments. But I'm getting ahead of myself because we haven't seen Regulation 6.
Well, I wonder whether you get that from Section 53 itself. Because Section 53(2) says where you have a central list and somebody designated, you have to show each hereditament occupied or, if unoccupied, owned by him.
Yes.
So even before you look at the regulations, I would have thought you'd take from Section 53 what this is meant to do is amalgamate en bloc all hereditaments belonging to a person, in this case Network Rail or whoever else it is.
Yes.
Is that not right?
Well, that's right. But my submission is that Victoria Station and Liverpool Street Station are hereditaments subject to the application of Regulation 6.
But only to the extent that they are actually occupied by Network Rail, and we know that not all physical space inside the station is occupied by Network Rail.
Well, my lord, but you get one of the issues in the case on ground 2 is whether the tribunal were right to say that this is all designed to take out the advertising hereditament before you apply Regulation 6 or to apply Regulation 6. I hear that my lord's making the point by reference to Section 53 2, but I have the same answer, which is Victoria Station and Liverpool Street Station are stations occupied by Network Rail, and therefore they are potentially within the central list. The detail of which parts of them stay in the central list turns on the application of the prescribed definition of the hereditament rather than coming out at the beginning. But that is the central issue on ground 2.
Well, you may get that perhaps from subsection 2b. Not only occupied, but falls within a prescribed description.
I'm grateful. That's a helpful indicator that at least for the purpose of section 53(2), we need to think about both elements, which is common to the way that the rating scheme works, because everything's done by relevant or prescribed, etc., etc. So, my lords, I'm going to go to section 64, which is the central provision in the case. Section 64(1) is what is being described in submissions as the normal hereditament. So, hereditament is anything which, by virtue of the definition of hereditament in section 115 of the 1967 Act, would have been a hereditament for the purpose of that Act, had this Act not been passed. And that definition, which I'm afraid you don't have in these authority books, but if I give you the cross-reference, it's in, you can see it at page 266 of the authority books. But I'll just read it because I'm not sure we need to get drawn into that at this stage. But that definition is property which is or may become liable to a rate, being a unit of such property which is or will fall to be shown as a separate item in the valuation list. And just for context, that definition was discussed in the case called Wall Lane, which you have in the authorities, but this case is not about 64(1), it's about 64(2). So I propose not to say more about that at this stage. Section 64(2) starts with the words that the tribunal thought were of particular significance. In addition, a right is a hereditament if it is a right to use any land for the purpose of exhibiting, advertising, and the right is let out or reserved to any person other than the occupier of land. And that's obviously the critical provision with which we're concerned. May I just observe that subsection A is an additional requirement to there being a right to use any land for exhibiting. It has to be let out or reserved to any person other than the occupier of the land. And then there's provision if there is no occupier, which we're not concerned with. And obviously that's the central provision. I'll come back to that as I develop my submissions. Subsection 3.
What about 2A? Because that deals with a right to use. Sorry, that's for the meters, isn't it?
That's right. Yeah, I think my lord might have in mind a different.
What sort of meters would that apply to?
I think it's electricity.
Not every meter under someone's cupboard under the stairs.
It says it says meters to measure a supply of gas or electricity.
It's specified by order.
As
My lord's question is the square bracket.
as
Yeah,
specified.
I'm just trying to understand what that applies to. If we could come back to that.
Yes. Okay.
Sorry.
No, sorry. Subsection 3 is a power of prescription, and when we come to see the central list regulations, one of the provisions in the Viaries is 65(3). I'll show the court that in due course. Sorry, 64(3). 64(4), which is over the page at page 17, is, if you'll recall, there are two requirements.
Forgive me, just the 64(3)
Yes.
provides that regulations may be made in particular cases, but it seems to envisage that apart from any such regulations, a thing might be more than one hereditament and might need to be designated as one, or vice versa. So
Yes, I think that's inherent in the concept of amalgamation. So yes, I would really accept that.
Sorry, but this is
no,
not.
this is an amalgamation. This isn't a central list provision. This
Well,
is,
it actually is an enabling power of the central list regulations, as we'll see.
well, it may be, but it's talking about hereditaments generally.
Yes.
It's defining them,
Yes.
and it seems to recognise that anything, may be more than one hereditament. That is to say, it may be rateable on different people in different hands. Is that right or not? Or is it a central tenet of rateability that any one hereditament can only be rateable on one person?
That's generally right. So there are some special cases in terms of sporting rights and
Well, I can see how that might easily be so if what is being rated is occupation of a space. And there is only one occupation of the space, and one of the things we've got to grapple with is whether that concept transfers to advertising rights, and that's why I'm interested in whether one can have more than one hereditament or not.
If I can put it this way, there certainly is the power to override what would otherwise be the outcome of the statute by amalgamating, joining, deeming, prescribing in such a way that there's broad powers of the Secretary of State that are embedded into the concept of the central list and, as you'll see, the definition of a hereditament.
But would it be fair to say that this seems to be a statutory recognition that in some circumstances, query what they are, one thing might be more than one hereditament on which rates may be levied on more than one person?
I wouldn't accept that actually. I think my submission would be that the scheme is about allocating. I qualify that by there might be special cases I don't immediately have in mind, but the idea is effectively the scheme is about allocating where, as between the central list and the local list, the taxation should be, and therefore it isn't, I would respectfully say, within that viaries to, if you like, tax the same property twice under the viaries of that regulation. I don't know if that addresses the point my Lord is putting to me, but that is my submission.
Thank you. Before we leave section 64, subsection 2 rates a particular type of right. Subsection 2A rates another type of right. Is it right to conclude that these are the only rights which are made rateable as such by the statute? You mentioned sporting rights a moment ago.
I'm sorry, there is some learning on sporting rights, but my learned friend,
Well, sporting rights were abolished.
Yes. So,
but in the about 10 years ago, I think.
right.
But weren't they in section 64, 65, and the language was slightly different. You rated the sporting right if it was severed from the land.
Yes.
And there'll be learning presumably on what was meant by severed from the land. But I'm not encouraging this, but do we need to know about it in order to understand subsection 2?
I'm not sure that we do. We thought about sporting rights and decided that there was
They're not going to help.
no helpful analogy to be made, but we did think about them in the time. So I think back to my Lord's question, I think we can proceed unless I'm corrected on the basis there are two types of rights.
Yeah.
In the scheme, advertising rights and meter rights.
Thank you.
And that might tell us something about how the central disputes work. If I may move on to section 60. Sorry, no, I'm still on 64 because I was going to show the court that 64.4, which is on page 17, is that a relevant hereditament consists of A, land, but E, any right which is hereditament by virtue of subsection 2 and 2A above. So the reason that's relevant is to go back to section 42 when we were talking about the contents of the local list. There were two relevant requirements. One was that it was a relevant hereditament, and the other was it's not in the central list. I readily accept a right would be a relevant hereditament by virtue of 64.4e. And then there's a wide definition of land for the purpose of subsection 2, which the court will find on page 18, subsection 11. Land includes a wall or other part of the building, and a sign, hoarding frame, post, or other structure erected to or to be erected on land. Then I then go to section 65, which the court will find at page 20, and 65.2 is the general approach to who the occupier is. So whether a hereditament of the land is to be occupied and who is the occupier shall be determined by reference to the rules that would have applied for the purpose of the 1967 Act had this Act not been passed. But that general rule is subject to the provisions that follow. See subsection 3, which says subsection 1 and 2 shall have effect subject to the following provisions. And one of the following provisions that's obviously important to the case and relied on in the reasoning of the Upper Tribunal, and which I accept there are bespoke rules for occupation, is subsection 8, which is a right which is a hereditament by virtue of section 64(2) shall be treated as occupied by the person for the time being entitled to the right. So where you have a advertising right, 65(8) tells you who's the occupier. What I submit is that 65(8) doesn't tell you how to approach whether the right has come into existence. That function is used by the words let out, and that's the issue in this case, what they mean in the context of a special regime with special rules for occupation, but where that concept has to differentiate between rights which are hereditament and aren't hereditament in a variety of factual contexts.
Well, your argument really does depend on the let out phraseology.
It does, and I
Entirely.
well, and the central list, but
Yeah.
the central list is the general is it does. I say though those are words with that carry an established meaning, and I accept they would need to be tailored to the particular circumstances of advertising rights. But my submission essentially is that it was a wrong turning to say they tell us nothing, and that the all of the learning about exactly that phrase is irrelevant to the question because of the special features. They may tell us something, albeit with caveats and the need to focus, but it goes far too far, I say, and the statutory reasoning is incorrect to say that the type of factors for differentiating where there is a functional link between the advertising and the occupation, and there are elements of control, that is immaterial simply because this is a, quote, self-contained scheme. It is definitely a separate scheme. It definitely has its own rights for determining who the occupier are, but I say it goes too far to say it's a self-contained scheme. It's not a self-contained scheme because it has to sit in the real world and it has to sit in the rest of the statutory scheme. And that's where the parliamentary language of let out starts to help us and tell us something. And what I say it tells us is that it is essentially separated from the host occupation. That's what that phrase means, sufficiently separated.
Essentially sufficiently separated
Yes.
from the host occupation
Yes. And
of what?
of the host hereditament. So the reason I call it the host occupation is if my lord goes back to 64(2), it's not let out in some abstract sense, it's let out to a person other than the occupier of the land. So you have...
Sorry to, but in this case, the host occupation of the host hereditament is the railway company's occupation of space, or
No.
the railway company's
No.
advertising, enjoyment of advertising rights?
No, it's the I submit it's the railway. My submission is it's the railway company's occupation of Victoria Station for railway purposes.
So it's not an occupation of a hereditament of the same kind as that with which we're comparing it. It's an occupation of space with which you say we have to analyse the relationship between that and a right to advertise.
Exactly, and that's inherent in the relationship because it's a special type of hereditament that is carved out from something, and what it's carved out from is an occupation. That's what it's said in terms. So my simple proposition is we should take an interest in understanding the nature of the occupation and the relationship, if any, between the advertising and the occupation. Now, in the paradigm case of a flank wall of a dwelling, there is no relevant relationship. So this doesn't complicate the law. it only complicates the law in messy factual situations. It doesn't complicate the law, it actually provides access to a font of jurisprudence on precisely this question, albeit one might need to tailor it to the particular circumstances of an advertising heritage.
But forgive me, I'm taking you out of your turn, but take a supermarket and it lets its advertising on the flank wall to A, exclusively to A,
Yes.
and inside to B. Are A and B both rateable in relation to the advertising rights they have?
So on the flank wall, I would say self-evidently yes. Inside the supermarket, I would say, on my case, that would depend on whether it's let out, and whether it's let out would take account of the extent to which there is control over the advertising and the extent to which...
Right, but assume that isn't the question. It's exclusive. It's exclusive to the advertiser. So that in that circumstance, you'd have a single building which can only be in single occupancy, because let's assume that no structure is applied to the flank wall. It's just using the flank wall to paint adverts on. But you've got separate advertising hereditaments.
Forgive me, I'm on the flank
Have
wall.
you in that example?
On the flank wall,
Yes.
it's self-evidently section 64(2). I think my lord was asking me about one of them was inside the building. Is that right?
Well, there's a single building.
Yes.
It has an outside and an inside.
Yes.
And leave aside for the moment the question of advertising on structures, on additional structures outside. Assume someone is granted the right to advertise by painting on the outside wall. That's A, exclusive. Inside, B, exclusively interior advertising. Are there two advertising hereditaments in that case?
So I wouldn't concede that B is. I would say that B requires an evaluative analysis. My lord says it's exclusive, but my submission is that an exclusive right to advertise inside a supermarket would not necessarily...
Well, it wouldn't necessarily be, but it would be capable of being.
It would be capable of being, absolutely.
Right, so potentially,
Yeah.
one can have, in that situation, two advertising hereditaments.
Oh, yes. I mean...
Even though there is only one building and only one single occupancy.
Yes, I mean...
So as between A and B, you're not applying any concept of it having to be one hereditament or another. They can each have their own hereditament.
It's a special hereditament. The question in each case, as between... so it's the host C in this example.
The host is C.
It's the host is C. So in each case, the question is, what is the relevant relationship between the advert and host C's occupation?
And assume in my example, none at all.
Yeah.
C's just letting them out.
Yes. So the answer is yes.
The answer is two hereditaments.
Yes.
A and B has
Yes.
one.
Yeah.
Now just change my example for a moment, and C lets out the advertising on the flank wall to B, but retains the right to advertise inside. So we've only got C and B. Are the two hereditaments, or do we have to apply some paramountcy test or control test to what is a single building?
In each case, I say you have to contemplate an evaluative inquiry between the relationship, if any, between the advert and the host hereditament. That is, I say, intrinsic in the concept of let out. And
But what is? But I think you're saying the host hereditament here is not, in my example, is not C's advertising inside the building, but is simply C's occupation of the building.
Correct. Yes.
And so you have to decide whether, in granting, I don't use that in a formal sense, when C grants or lets out to B the right to advertise on the flank wall, you're comparing B's ability to exercise its advertising on the flank wall with A's occupancy of the building. Is that right?
Yes.
That's the comparison you say has to be made.
My lord, if it helps, can I show you paragraph 59 of my skeleton argument, which tries to condense what I say the relevance inquiry is.
Yeah. I'm sorry to slow you down.
No, no,
I'm
if it
interested.
helps, it
I'm
gets to
interested in
another
exactly how you put this.
Yeah, no, so I think it's helpful to show you the way we put it. I don't resolve from this in paragraph 59, page 30 of the core bundle. So, if we think about this through the prism of those examples, just briefly, to assess whether advertising rights exist as separate hereditaments, I say in this case, but I think this is general, it's necessary to understand the nature of the host's occupation and understand the relationship of the display of the adverts to that hereditament, and in that context to determine whether or not the rights granted by the host are sufficient to amount to a letting out.
Yes, and
So-
then I ringed because I thought it was at the heart of what you say at 60. Critical point is the concept of letting out, raise an inquiry about the relationship
Yes,
of the putative hereditament with the host's occupation.
exactly.
But we are, I just want to be clear, we are comparing two different things. The host's occupation is occupation of physical space.
Yes,
The hereditament we're concerned with is an advertising right.
the putative hereditament.
Oh, putative hereditament.
But yes,
Right.
yes, yes. Yeah,
And-
that's inherent in section 64(2).
And how, in my flank wall example, does one make that
Well,
comparison?
because there is no relationship to compare in the paradigm case. And that's if I could hold that thought, that's exactly why this provision came on. I'll tell you where I'm going with this, is why did this provision come into existence? It came into existence because before we had this provision, you had the rule in relation to what's called advertising stations, and they were either, if you like, not occupied by anybody, and then there's a special rule deeming, or they were occupied, they were bolted on, they were an advert bolted onto an occupied premises, let's say a dwelling house, and the iniquity was that section 4 of the 1889 Advertising Stations Act, which I'll show my lords in a moment, added it to the occupational right, and that was found to be unfair, and so there was various attempts to work around that, and in response to that, section 56 of the, section 48 of the section 56 of the 1948 Act was enacted, which is what this became. So the paradigm case was one where there was no relationship, it was inherently separate, and so the question that this case gives rise to, that no one's ever grappled with, is, well, how do we approach this in the context where that paradigm doesn't exist, but there is actually a control-based relationship, and I would say a functional relationship. And that's
I've not quite understood the functional relationship.
Well,
I understand
yeah.
the control
Yeah.
in the sense that there are certain standards you have to comply
Yes.
with, and so on, and there's an ability to interfere for operational reasons and so on. I understood the functional relationship. Is it just that you're getting money from it?
No, well, no, but that was the discussion we had earlier. I said it was on the par with electronics, but I also said, in the context of the overall statutory scheme, it's a railway purpose. So
Yes, but that's what I'm having difficulty with. I understand you're going to show us the historic statutes which treat advertising as a railway purpose, but if you leave that aside, on the facts, how does having adverts at a station help you to run a railway apart from generating money?
So I will. Well,
That's what I'm struggling
yeah,
with
but,
at the moment.
my lord, I hear that, and I will deal with that. But at this level, aren't we dealing? I would respectfully suggest with actually what the right approach is, and so one could envisage cases. Let me give you an example: a cinema where there is an advert. There's the host hereditament is the cinema, and there is the right of the film company to come and display a film advertising the film that's showing in the cinema.
Yes.
So there is a very, very, very close functional connection between the advert and the host occupation. On the Upper Tribunal's case analysis, that is entirely immaterial. I say that is fundamentally wrong. So I hear that my lord's not with me on the functional connection, but to test the point, we've got to imagine a situation where there clearly is a really close functional connection, and the vice of this tribunal's decision is to tell us that that's in the bucket of an immaterial consideration. I say that's inherent in the concept of let out, you've got to think about the connection. And in my lord's example of the flank wall, there is no connection. It's really simple. But there are cases that fall in the middle ground.
The supermarket might well want to impose controls on what is on the advert, so it might not want people to advertise, I don't know, sex shops or something outside its supermarket. It might also have a minimum payment, annual payment, and a sharing of profit. But those things by themselves, would they make any difference on
Well, what is my proposition at this stage is that those factors are capable of being relevant. We need to understand what let out means in a context that's capable of taking account of that. In the example that my lord's just given me, it's not a particularly strong one. In my cinema example, I would respectfully say the functional connection is very strong. And the point of approach is that strong but irrelevant? And my submission is that's surprising for a statutory provision that came into existence with the flank wall of a dwelling house example in mind. And I'll show you why I say that. But so I say the mischief is attributing the value of the advert to a host occupation which has no connection to it. That's the mischief that gives rise to the separate advertising right. This case is about, it might not be the best example of it, but the point
Sorry,
of
could I just write that down? The mischief is in attributing the value of the advertisement to
a host occupation.
a host occupation
That's nothing
which has nothing to do with it.
Precisely. And I'll show you why I say that in a short moment. May I come back to section 64 and 65 just to finish that off, because I'm anxious to show my lords the history, because I do think this might assist with some of the points that are obviously exercising the course, which I want to maximise my assistance that I can give you on those. If one goes to section 65 next, I think I've shown you the definition of that. So section 65, subsection 2 is sorry, we were on this. Forgive me, I've slightly lost where we were.
Yeah, we've done
I've
this.
shown
And
you the
we've gone through to
definition.
8 as well.
So thank you. I'm further ahead than I thought I was, although not by much. But may I go next to the central list provisions, which my lords will find at page 26. But before we go there, just to could I just ask you to turn to page 93 for a moment? Because on page 93, which is the previous version of it, you've got this is printed better. It gives you the viaries, and I think that's important given where we were on the statutory scheme. The viaries for the central list regs are section 53, 1, 2, and 5, and 64, 3. That's why I was making that point there, and then other provisions. So those are the same ones on every iteration of central list regulations. But I respectfully say it's worth having those in mind. So how do these work? Well, this is the 2005 regulation. Regulation 1, we need to have in mind what a designated person is.
Sorry, you're on page.
Oh, so sorry, page 26. So regulation 1, we need to think about who a designated person is. And that means the person designated by regulation 3. Regulation 2 tells us when they come into effect. Page 29, please, the definition of the designated person. So for the purpose of section 53(1), there are designated the persons named in the schedule, and there is prescribed in relation to each such person the description of the hereditament set out opposite the name of that person in the schedule. And then subsection 4, content, regulation 4, next page, content. The central list shall show the name of the person, and against each person, each hereditament situated in England, which on the day concerned is occupied, or if unoccupied, owned by that person, and which falls within the description prescribed in relation to that person by that regulation. So this is part of a concept of prescription that we saw under the enabling provision that my Lord Justice Holgate indicated when we were talking, I think, about section 53. And then we get to the railway hereditament, which is the critical provision, which is regulation 6, page 32, and may I take the court through this and then set out what the competing approaches to this are. So where Network Rail Infrastructure occupies, or if it is unoccupied, owns any hereditaments, and I appreciate the court's exercise by that, given the decision of the Upper Tribunal. For my purposes, I'm going to say that the hereditament we need to think about there is either Victoria Station and Liverpool Street Station, or perhaps better, both Victoria Street and Liverpool Street Station, because it's about potential amalgamation. But it's the unit, the relevant unit is the station. So where Network Rail occupies any hereditament, and then going beneath the letters, and if apart from these regulations, those hereditaments would be more than one hereditament, and each hereditament satisfies the conditions in paragraph 3, those separate hereditaments shall be treated as one hereditament. So, my lord,
You said that's the exercise of the power in 64.3.
and section 53. But yes, it's both. It's both.
Is it both?
Not-
She said section 53 the rate, but it's fine.
Section 53 is the
It's reg 3.
My lord, I say it's both. I'm not sure I need to differentiate. I'm not sure one can differentiate between which particular part of the diaries this relates to. But I say it's both. But may I then go on to what the conditions are? So that's over the page at page 33. The conditions are that the hereditament, again, I say we're thinking about the station at this stage of the analysis, or the potential amalgamation of both stations, is used wholly or mainly for railway purposes and is not an accepted hereditament. So we need to understand those two concepts. Railway purposes is defined over the page on page 64. Railway purposes means the purpose of providing railway services within the meaning given by section 82 of the Railway Act of 1983, or purposes ancillary to those purposes, including, and I'm going to miss some words out and I'll explain why, including the exhibiting of advertisements, because I submit, and the history will bear this out, that you read those two things disjointedly, they're alternatives. So it says including the purposes of providing policing services, all the exhibiting of advertisements, including the exhibiting of adverts. So under the statutory scheme, the exhibiting of adverts is a railway purpose. That's accepted, but my learned friend says, well, you'll get to that, and that's the issue between us. But it's common ground that the exhibiting of adverts is a railway purpose.
Well, can be as well.
Yes,
If
yes,
it's ancillary to providing railway services.
yes. No, well, that's for all purposes ancillary to those, including the exhibiting of adverts. We say that the statutory scheme is proceeding on the basis, and I'll make this good by way of the history, that the exhibiting of the adverts is a species of a railway services.
All advertising
Yes.
of whatever kind
That's my
is a
submission.
railway purpose.
That's my submission. And I say that submission, which might be slightly not self-evident on this construction, that's supported by the history. I say that's supported by the history when we look at it. But that is my submission.
Yep.
That it's not just advertising a train ticket to Brighton, it's advertising in the railway that is a railway service.
And irrespective of any control over the advertising. All advertising, even that which is completely devolved to the advertising company with no control over whatever, it still, you say, comes within railway purposes or not?
It does, yes, but it doesn't necessarily come within accepted hereditaments, because we're going to come to that. But the direct answer to my question is yes.
Yeah.
So because that's only railway purposes, would it help? We need to come back to accepted hereditaments, but just to continue that thought, you see the cross-reference to the Railway Act of 1983. Shall I just show you that? All it says basically is that railway purposes include station services, but that you'll find at page 23. meaning of railway services. In this part, railway services means services of any of the following descriptions, that is to say service, station services. So that is so that's what railway services means. And then if we go back, please, to the I've still got to deal with the accepted hereditament. And so we're on page 33 for this. So the accepted hereditament means you'll see there, just to ask you to notice these, because you'll see that these have quite a long historic origin. So premises used as a shop, hotel, museum or place of public refreshment, there's offices, etc., any person designated, etc. And then R1C, premises or rights so let out as to be capable of separate assessment. So the way I say this works is you've got Network Rail occupying the station. The occupation of the station is for railway purposes. The adverts are included in railway purposes because of the definition of railway purposes, but they're only in the railway hereditament if they are not let out so as to be capable of separate assessments. And my submission is that that's essentially the same evaluative inquiry as I say arises under let out section 64. So on my approach, both provisions lead to a same place. On the valuation officer's approach and the tribunal's approach, because you formed a view that it's not let out, and because you know it's occupied by the person whom the right is granted if it's a hereditament, you therefore never get into this regulation because it's taken out at source. And that is a misstep, I respectfully submit. And the vice of that is it doesn't make any sense of the inclusion of rights in subsection C, and it's discordant with history. So that's where the pinch point in the analysis is. I say these work seamlessly if you input the relevant unit of occupation. And just to foreshadow where I'm going, when you go to Southern Railway, that's exactly how Lord Wright, the Master of the Rolls, approached the analysis there in deciding whether premises were carved out from the railway hereditament, and structurally rights have been inserted into these regulations in precisely the same way. So it makes no sense to take them out at source, and that was a pivotal part of the tribunal's reasoning. Now I say that on the statute, and I say it much louder and much more forcefully when we look at the history, which is where I turn next.
Just before you got to the end of the regulations.
Oh, I think so.
Yeah, okay.
Subsection 5.
One provision I meant to ask your help on, going back to the 88 Act itself, at page 21.
Yes.
You look at subsection 8.
Yes.
8 capital A.
Yes, I thought, my lord, thank you. I had meant to say something about that. So,
Can you just look at it?
Yes. So, yes.
Because that's dealing with land consisting of a hereditament.
Yes.
Used for the exhibition of advertisement.
Yes.
Section 64(2) doesn't apply.
Correct.
And apart from this subsection, the hereditament is not occupied.
Correct. In old language, it's an advertising station.
And by that you mean?
Section 3 of the 1889 Act, and I'll show you exactly where that is, but that's the statutory predecessor of that. And just to foreshadow that, one needs to have in mind the difference between advertising stations and advertising rights, and the tribunal didn't have that in mind and muddled them up in a way that impacted on its analysis, and I'll show you that once we've been through the history. So if we could then please go to the history.
So forgive me, what is section 8A, subsection 8A doing?
I
haven't quite understood what
it's not in play for the purpose of this case.
No, but what does it achieve that wouldn't be achieved if it weren't there?
It covers where there's no occupier, but there's an advertising station.
As defined in section 3 of the 1889 Act.
well, it's the I'm not sure that it does it by cross-reference, but it's
No,
exactly that
That,
provision.
it's that
It's
same
exactly that provision,
it's that
exactly.
concept.
Exactly.
But this is talking about a physical heritage.
Yes. I think once we've done the history, I can show you this much more clearly. May I just for now ask you to take it on trust that that's about advertising stations, and I'll come to exactly how it works now, if I may. So for the history section, I hope it's helpful to just go through chronologically how things happened, and to the extent that I can, why they happened. And this is about advertising, and then it's also about railways, and then obviously it's about advertising at railways. And I'm going to go in a moment to, there's a very helpful and pithy extract from an old rating textbook called Amy's, which was written in 1964, which is out of print now, and it's at page 573 in tab 834, and that gives us a clear overview of the history. I'll go to it for one point, but it will help to make sense of the points I'm making. I'm going to take you briefly to the statutes, but if I could start, I'm afraid, in the 19th century, but I'm going to go quickly. So before there were any special approach to advertising, difficulties arose under the general law of rates as to whether there was a rateable occupation. And so the case that's in tab 15 of the Bundle of Authorities at page 100 is a case called St Pancras Assessment Committee. We don't need to go to it, but that is a problems with occupation under the general law of rates case. So the first parliamentary intervention was the 1889.
Well, it is the upshot of that case that there was thought to be no occupation.
Yes, in that case there was no occupation. It was a hoarding.
And there seemed to be two different explanations by the judges. Mr Justice Mellor said the owner hadn't parted with exclusive possession. One was dealing with a mere easement.
Yes.
And the statute fastens onto rights eventually. And then Mr Justice Last said there was a lack of permanence, and he seemed to be applying the fixture principle you see in property law.
Yes.
Have I got it in a nutshell?
Yes, I'm sorry, you've got it in a nutshell and in more detail than I needed, but the general...
Well, maybe.
No, possibly not, but the general point being there were difficulties in fitting an advertising scenario into the four ingredients of rateable occupation as they came to be declared later. So Parliament intervened. My Lord Justice Holgate is obviously familiar with this, because some of this was set out in the Court of Appeal case of O'Brien we will look at, where my Lord Justice Holgate was counsel for the revenue. But for my purposes, it just helps us to understand the first parliamentary intervention.
Just before you leave St Pancras,
Yes.
so if you have a house and you put adverts up in front of it, that's all treated as part of the house?
Not yet, my Lord. So on St Pancras there was a structure that was added to the front of, I think, a vacant house. Which,
Well, one was vacant, one was occupied.
right, and it was about whether
it could be separately assessed as a separate hereditament,
Yes.
and they said no.
Correct.
But I thought it left open the question whether it could be treated as enhancing the value of the house behind.
Yeah, yes, because it would be part of the. Because it would be part, yes, and that so my Lord, yes, so the rateable occupation would be the house, but the house would be valued taking account of the advertisement. I have no difficulty with that, and that my submission is that's the structural answer, where the advert very closely relates to the functional use of the hereditament. Is you add value to the rateable value to reflect the advert if there is extra value, and we're just a special case of that, I say, in terms of the railway hereditament. But if we just had a single local list hereditament and there was an advert saying let's say there was a sign there that was advertising a sandwich bar or something like that, then you could form a view about whether that sign added some value to the occupation of the property. Generally it doesn't, but if it's a particularly prominent sign it might, and that's orthodox. So far I'm pre any statutory intervention, but the next stop is the 1889 Advertising Stations Act, which is behind tab 5, page 56, and I'll just take this very briefly because this isn't now a case about that, but we need to understand what this case is about in the context of this, I would suggest, in the context of this provision. So under the Advertising Stations Act 1889, there are basically two routes to liability. There's section 3, which is where land is used for advertising and not otherwise occupied. And that's section 3 on page 56. And then section 4 is where there's occupied land and it's used for advertising. And that's the provision, if you'll see at the end of that, where the approach is you estimate the value to include the increased value of the use aforesaid, i.e. the advertisement. So that was that intervention, and that's well explained in the Amy's extract. If I could now go to the Amy's extract, which is at page 575. Pick it up at 575. So the person, so I'm just on the first full paragraph there. The person permitting, so it's just referred to section 4, which you'll see referenced in footnote 20, which is section 4, which is exactly where I was. And then this is the commentary. The person permitting the use to be rateable according to the value of the use where the land was not otherwise occupied, but where the land was otherwise rateably occupied, its gross value and rateable value were to be estimated so as to include the increased value from the advertising use. This meant that in either case was the advertising contractor himself rateable, and where a landlord let a house to a tenant and its side wall for advertising to another person, the house tenant was the house tenant was rateable for the advertising use from which he derived no advantage. So that's the problem or the mischief of section 4, is it attributes positive value to somebody who derives no benefit from it, where because it is a separate use. And then there's discussion about that. To avoid this inequity, the Central Valuation Committee recommended the rating authority should try to persuade the person permitting the advertising station to be used or advertising contractor to agree the value. And then the Local Government Act of 1948 sought to get over these difficulties by enacting that, and that's the provision that gives birth to the advertising right, which is basically what is now in section 64.2. So that's where I would go next, but I do rely on that. And just for your note, the Upper Tribunal mentioned that passage effectively in its decision at paragraph 30. But that is the best articulation of why you need the advertising right. It's because there's an inequity where there's no connection between the right and the host occupation. And my point is, our case doesn't fall into that category. But in any case, there are cases that don't fall into that category.
Can I, sorry, forgive me.
Yes.
Just coming back to what the position is now, I suppose the sort of, is it your case that if your clients don't let out in the relevant sense the advertising rights, that their rating valuation on their occupancy of the stations needs to be increased to reflect the value of that advertising right?
It doesn't need to be increased because the cumulative value already increases. It already includes a substantial. The cumulative value already includes a substantial amount for advertising. So yes, it does.
Where do we see that?
How is that valued?
Well, we haven't got the detail of valuation, but we have got the part of the cumulo includes property income, including advertising, and it's discussed in this. It's discussed below in the evidence of.
Is the cumulo less than the sum of its parts? I'm just trying to work out what
it's valued.
Why Network rather interested in arguing this case. Is it because actually, if you attributed to the occupancy of the stations the advertising revenue which they could in fact derive, or do in fact derive, and they are to be treated in cumulo, that is actually less than the sum of all the advertising revenue,
Well,
value of the advertising revenue? Is that I mean financially?
No, well,
is that what the case is about?
no,
for
it
your
is,
clients?
well, not necessarily. I mean, the answer should be neutral financially.
Yes.
The answer schematically should be, if this advertising is in the central list, it should be properly valued, and if it's been undervalued, then that can be corrected in due course and subject to not being retrospectively increased. There is actually a substantial portion of the cumulo that relates to that. Well, the actual direct answer to my point is because it's extraordinarily inconvenient for these individual sites and rights to be separately assessed. It will create an enormous amount of work for the valuation officer, for JC&Co and for Network Rail, and it's not an answer that we say arises naturally from the statutory scheme, which is why it's been litigated.
So far as the valuation of the heritage in the central list is concerned, I mean, in the old days, sometimes statutory instruments prescribed a value or prescribed a formula.
Yeah.
But is this an example of a central list hereditament where you just assume a hypothetical letting of the overall hereditament? And I can hear the whispers.
Yeah,
I mean, I was going to guess it's the profit, what you used to call the profits method.
Yes.
The receipts and expenditure method.
I believe, to be absolutely accurate, the current valuation may have been arrived at by what's called a short-term receipts and expenditure, but
Which would involve taking a gross revenue and applying a percentage to it.
which would include the advertising rate, which is the conceptual point that answers the discussion. Is that less than some of the parts? It might well be, but that's not actually what this case should be about.
No, so if one's looking at someone who doesn't come within the central list, then the primary element of dispute ought to be financially neutral.
Yes. Yes, I absolutely endorse that. This is about where the most convenient place for the advertising value to be captured. That is what this case is about. And my submission, in terms of the essential rationale for this, is that for very good reasons, Parliament created an advertising right. Those very good reasons were there was no connection between the advertising and the host occupation. It diminishes as a good reason the greater the connection between the advertising and the host occupation.
It may be financially neutral as a whole in theory, but it makes a big difference on whom it falls. Because if the advertising rights are let out within the sense, then they fall on the advertiser.
Yes.
And I know we have the indemnity in this case, but in other cases the position may be different.
That's right, my lord. And there may need to be marginal issues. There may need to be some litigation around marginal issues. The reason that this is coming to the court might be, I don't think I can say this as a definitive proposition, but because we're starting to see cases where there's a less obvious disconnect between the advertisement and the occupation being treated as advertising rights because they're seen as potentially valuable if they're captured on the local list. So, but my lord, it is about the incidence of liability rather than the quantum. I respectfully say that, and I say the extra element here is about the benefits of amalgamation, which is, I say, a statutory purpose as well.
Yeah, but so I'm, make sure I'm keeping up. If section 64(2) applies for the sake of argument to the advertising spaces in question,
yes,
they don't form part of the cumulo hereditament.
Correct.
So when the receipts and expenditure method is applied to that hereditament, it won't take into account any revenue attributable to those spaces.
Correct. If done on a new list. If done on a new list in this case, and I'm not taking this as a point.
I'm just trying to understand the principle.
Yes.
If section 64(2) applies to these spaces, they will be deemed to be in the occupation of Deco.
Yeah, if they're not in the central list, yes.
Yeah. And what valuation method is used there? Is it income-based, profits-based?
I think it's comparative based, is it? Income or comparison.
Yeah, so same difference.
Yeah.
I see.
May I return to?
But either way, either exercise means adding up a lot of components.
No, well, not-
Certainly to get to the cumulative value.
I'm not sure it does in this case, because it's a light. I mean, the valuation methodology.
You have to count each one separately, whether you treat them individually and send out separate bills on a local list, or you have to add them up.
I'm not sure I follow that one. Maybe my fault. But there's an accounting mechanism under the agreement.
Yeah.
If it's a receipts and expenditure valuation of the cumulo, there is a single item of the revenue from, I would have thought, from the revenue from advertising. One has to interrogate the accounts to work that out.
You've got to add it all
Or
up.
you do
Someone's
it
got
in
to add
forms-
it up.
Well, my respectful submission is there is a very significant difference between a single amalgamated entry in the central list that captures advertising and the atomisation of that on the local list in terms of workload, convenience, the need to track each item if something changes, if it's taken out. If Network Rail exercise its powers to remove adverts, it will need to come out of the rating list. There'll need to be the correct identification of them and no confusion as to the value. There is a whole host of practical reasons, I would respectfully suggest, where an atomisation of single entries causes obvious inconvenience of a step change more than simply having it from the cumulo assessment. And my ground for it is that the tribunal were wrong to say all of that was irrelevant, but I'll come to that. But my lords, may I go back to the history? So we've just looked at the mischief which arose under the 1889 Act, and then we get the creation of the special regime for advertising. And I'll take this quickly because we're not dealing with these provisions. But may I just go through the history in this way? So at page 60, you see the section 56 of the Local Government Act 1948, which is at tab 7, and it's got the phrase with which we're concerned here: let out or reserved to any person other than the occupier of the land. And to try and take this quickly, so that was the provision as enacted. As a side note, there was a valuation glitch, and this comes back to a discussion I was having earlier with my Lord Justice Popplewell. There was a valuation glitch from the drafting because the right itself was held to be what was rateable, whether or not it was exercised, and did not include the value of the structure on this provision as it was originally enacted. That went to the House of Lords in a case called Imperial Tobacco, that's at tab 19, and it led to a change, a new approach to valuation, correcting and reversing Imperial Tobacco in the Rating and Valuation Act of 1961, see tab 9. I don't think we need to worry about that, at least for the purpose of my overall history, but that explains what Imperial Tobacco was about. Now, this is where I say the history starts to become quite important. So at this time, there was
Just as before we leave section 56,
yes.
what seems to have happened there in the first 2/3 of the section is that what we now find in section 64(2) plus section 65(8)
Yes.
was actually run together in the
Exactly.
same provision.
That's exactly right. I accept that 100%. That's exactly right.
Thank you.
You see that under the General Rate Act as well.
Yeah.
And so you can see that many of the provisions actually are successors to specific provisions. So my Lord's exactly right.
I mean, but if I've followed you, your argument is dependent upon let out, what does it mean? But it's also dependent upon reading in a paramountcy of occupation test into the application of that provision.
So I didn't put it. I did not put it in terms of paramountcy of occupation. I said there is a body of case law
Yeah.
which insists on what let out means. The concept of paramountcy is about competing occupiers.
So what does it mean if it's not paramountcy of occupation?
Can I come back to that?
Because I need to understand.
No, of course you can. Now, let me come back to that. May I make my point on this statutory history first?
Because before we leave the 61 Act at tab 9, and I understand this was correcting a particular conclusion of the House of Lords and Imperial Tobacco, the way it's phrased at the end of subsection 1, notwithstanding that the structure was provided or was provided after the right was let out or reserved. It sounds like it's referring to the creation of a right or the creation of a reservation. Likewise in subsection 2.
Well, that's
The
dealing with...
separate hereditament should be treated as coming into existence at the earliest time in which either any structures erected after the right constituting the hereditament has been let out. That's Parliament describing what it thinks it's been doing in section 56.
Well, my respectful submission is it's Parliament describing section 56, which begs the question, what does let out mean, which is the issue in this case.
Well, yes, but on one view, one could say that let out or reserved is simply a very straightforward term referring to the creation of the right.
Yes, you could say that. My submission would be that that's wrong, and that doesn't reflect the meaning of the words let out. It doesn't reflect the way this has been crafted in the current legislation. But one could say that. One could reduce down the concept of let out to grant, but then you ask yourself, if you go back to section 64(2), what is A doing? Because you've already got the existence of a right. If you just go, there's two parts to it. There's an advertising right, and the right is let out or reserved to someone other than the occupier of land. So the problem with what my lord's putting to me, I say, is it conflates the deliberate language of let out, which I say, understood through the prism of history, suggests a sufficient degree of separation rather than mere grant. But there's no...
You need a verb to connect it with the third party, and it may be doing no more than that.
Well, but they've chosen a term. My respectful submission is they've chosen a term which has already been used and has already been discussed in cases like Southern Railway, albeit there's points about is it precisely the same term. But that's why I want to finish this piece on the statutory scheme, because my submission is yes, it is precisely the same term if you read the statutory scheme together. So I'm sorry if I hope that does address expeditiously the point that my lord's putting to me, which is at the heart of the case, and I will certainly come back to it. But I just, for current purposes, I just want to trace the history, because I say it's helpful. So my lord had already gone to section 50, the 1955 Act. I want to go to subsection 5, which is on page 65 of the 1955 Act, which says section 56 of the 1948 Act, which provides that the right to use land, including hoardings or other structures for the purpose of exhibiting advertisers, is separately let out or reserved. That right is to be treated as a separate evidence for rating purposes. Emphasising shall not apply to any right to use for that purpose any land forming part of a railway hereditament as defined by section 86 of that Act.
So that just excludes the
yes.
application of section 56, and in that situation, you don't need your let out argument at all.
That's true, but I don't know I'm on a slightly different point. I'm on the point that goes to my ground.
I'm on a slightly different point.
Yes, that's true, but my submission is that the properly understood framing of this in the railway context and the proper approach to let out work in tandem.
Because what happens, just without spending time on this, is that exclusion appears also in the General Rate Act of 1967. That's where you're going. But it doesn't appear in the 1988 Act.
May I take that?
Okay.
That's true, but then where does it appear? It appears in the Central District. So may I try to just...
Sorry, that provision which explicitly says section 56, what is now section 64(2), doesn't apply. You don't find that in the current legislation, do you?
That's correct, but may I show you what you do?
Yeah.
What you do find and how it relates to what was.
Well, you find the language which existed all the way through, with and without that exclusion.
Well, yes, but you also find other things. So yes, that's what you find in the primary legislation. You find other things that are quite important in the secondary legislation. So far, my lord's ahead of me, but I've been to section 55, which is the express exclusion. Now, so I just invite reflection on what that's trying to do. I would respectfully say what that's trying to do is bake into the statutory scheme a concessionary approach to advertising rights at railway stations.
You said section 55, but I think you mean section 9(5) of the 1955
I
Act.
do, and I'm really sorry.
Do we get any help from 9(6)? Because 9(6) seems to envisage that a railway hereditament might be occupied by the British Transport Commission for non-rateable purposes, i.e. running a railway,
Yes,
and for other purposes,
yes.
including the letting out of rights such as are mentioned in the said section 56.
Does it, my lord, does it say that? I don't know if it, I don't think it does relate to, as I understand it, that section, because we'll see that again in the General Rate Act, I think that is, sorry, forgive me. So that's saying if you've got an amalgamation of purposes.
It seems to be treating the letting out of advertising rights
Yes.
as other purposes, or at any rate capable of being other purposes, that is not for non-rateable purposes, which I assume means transport, running a railway.
I don't think that's the effect of that provision. So where a railway and canal heritage was occupied by the British Transport Commission, partly for non-rateable purposes and partly for other purposes, and the other purposes consist of advertising, then part 5 of the 1948 shall apply to hereditament as if the purposes specified in A and B were included among the purposes specified in 86 as non-rateable purposes. So it's deeming a part advertising,
Yes.
part other things to be railway purposes.
Yes, but it plainly envisages that if it weren't for this provision, there wouldn't be railway purposes.
Yes, but at this point you don't have a statutory definition of railway purposes that includes advertising, as I understand it, because it's in this primary provision.
Right, I see. Okay,
So-
thank you.
Yes. So so that's the 55 Act, and just in terms of the continuity of this, I make this point in paragraph 35 of my skeleton argument. The first valuation list under the 1948 Act was in 1956, so that carve-out provision for the railway was, if you like, in place at the moment that the advertising rights regime came on the books, as it were. So there was always that carve-out for railways in 9 subsection 5, because there was a delay in the implementation of the valuation list. See paragraph 35 of my skeleton. We then get to the General Rate Act, and my Lord Will Justice Holgate has in mind, but that's section 28. But now, may we look at this briefly but carefully. So, as the court may appreciate, the 1967 Act was a sort of super consolidating act, so it brought together a whole disparate range of.
Was the previous General Rating Act in 1925? Because we jumped from 1889 to 1948, but there was a general rating statute in 1925.
But there was nothing on advertising rights.
And so what happened was that what we found in the 1889 Act continued to apply until we get to the 67 Act.
Yeah.
And what was previously sections 3 and 4 are included as subsections of section 28.
That's where I'm going now.
Yeah, okay.
So there may
I just want to see the big picture.
Forgive me. There may have missed a sequence out, but it wasn't a sequence that was relevant to advertising rights.
Yeah.
But it is for advertising stations. But I've only going to advertising stations to help to understand the provision. So can we look at section 28 now? This is the General Rate Act, and which is a consolidating provision. So the heading there is misleading because its heading is advertising station, but as my Lord Justice Holgate has just indicated, only subsections 3 and 4 are about advertising
Well,
stations.
they're the only bits which derive from the 1889 Act.
Yes. And
Is advertising stations defined somewhere in the interpretation provision?
I'd have to check that.
Yeah, okay.
I'd have to check that. But in terms of the language of advertising stations and advertising rights, and I've been differentiating between them for reasons that I hope are clear on the statutory history, we need to notice that subsection 1 is about advertising rights, and that is, if you like, the successor to section 56 of the 1948 Act and the predecessor to.
Well, I don't know how big a point this is because you make a point about the 1948 Act changing things, but at section 56 on page 60 of the authorities bundle, the marginal note again causes them calls them advertising stations, calls us the rights to use land, and says they're to be separate hereditaments.
Sorry, Bernard, where? may I
This is
go
page
back?
60 of the authorities fund.
Page 6.
It may be that advertising stations don't appear in the body of section 56,
Right,
but they're there in the marginal note again.
right. So, but then there's two types of. So maybe that is a generic term of art.
Yeah. See, well, that's how the draftsman seems to be using
yes,
the 67 Act.
But one, I think, to be precise, one needs to think about three different types of machinery, of which one I'm going to call advertising rights.
Yeah.
In order to be clear, but my lord, if that's I was only actually trying to. I wasn't taking a point against the drafting of this, but this is something that's picked up. I would respectfully say imprecisely in the Upper Tribunal. I'll show you why I say that in a moment. But just at this stage, I'm just trying to understand what this provision does. So, advertising stations, subsection 1 is what I am calling advertising rights. It is the predecessor, as I've said, to section 64(2), and it is the successor to section 56 of the 1948 Act. Subsection 2 is the successor to the 1961 Act, which is correcting the valuation of imperial, the reversing imperial tobacco. Subsections 3
Sorry,
and
can you say that again?
Subsection 2 is consistent with the 1961 Act, reversing imperial tobacco, so that you rate it when it comes into the earliest point of its erection,
Well, it takes into account the structure, even
Yes,
if it's
exactly.
erected
exactly,
after the right is conferred.
exactly right. So and then you've got subsections 3 and 4, which are the successor to the advertising stations, and then you've got subsection 6, which is a continuing of the disapplication of advertising rights to the railway hereditaments. Now, at this moment, can I invite attention to what the railway hereditament consists of, which is page 70, section 32. And section 32, subsection 2, there shall be treated for the purpose of this section as railway and canal premises, any premises of any of the following descriptions, namely A, premises occupied as a dwelling, hotel, place of public refurbishment, and then C, premises so let out as to be capable of separate assessment. Now, my lords might recognise the language of that, because there is a very close relationship between the language of that provision and the language of Regulation 6 of the 2005 Central List Regulations, which I showed you. The difference is that here it says premises are let out so as to be capable of separate assessment, because there was an express provision disregarding the rights earlier in the statutory scheme, and so it doesn't talk about rights because they're never in play. What then happens, I submit.
So is it,
Were the only rights, as opposed to physical hereditaments, that were rated by 1967, the advertising
I
rights?
think sporting rights.
well, sporting rights seem to be dealt with at section 29, bottom of page
Oh.
669.
Yeah, but I don't think they were exercised on the railway. So for our purposes, for our purposes, yes, I would say.
You could envisage sporting rights being exercisable over canal premises.
Yes, no, that's a fair point. Yes.
Anyway.
So
But if I've understood what you're saying, what we see in the 48 Act going through to the 67 Act is an exclusion of what is now section 64(2) and 65(8),
in relation to railways.
which you say is the explanation why, when we turn to 32(2)(c), it uses the words premises
Yes.
rather than premises and rights,
Correct.
because the rights had already been
Correct.
subject to pointed out sporting
And
rights.
so what happened in 1988 Act, and this is the point that I do emphasise, is that the special regime for advertising, the advertising rights regime, stayed in the primary legislation, but the special regime for railways moved into the secondary legislation. So what was section 32 subsection 2 moved into the secondary legislation. So the valuation officer in their skeleton argument says, well, section 32, sorry, what is section 28.6, thank you, is removed from the primary legislation. True, but incomplete, I would say, because what actually happened is advertising structurally stayed in the primary legislation. Railway structurally moved to the secondary legislation. So I say structurally, you can only understand the relationship between advertising rights and railways under the 1988 Act if you read the two of them together, rather than say that you never get to.
Your submission is that Regulation 6 of the Central Listing Regulations is doing the same thing as Section 28.6.
Yes, exactly so.
It doesn't use anything like as clear language.
Well,
I mean, 28.6 uses very clear language,
well,
which says Section 56, or whatever it's become, Section 28.1,
yes,
shall not apply
yes.
to railway premises. We don't have anything that is anything like as clear as that in Regulation 6.
No, but you do have an addition carved into the structure of an already pre-existing statutory provision. Premises, previously said premises so let out as to be capable of separate assessment.
Yeah.
You've inserted into that premises and rights.
Yeah.
So you're saying that what we find in 32.2c, page 70, is adapted in the regs under the current legislation by the addition of the word rights.
Yes.
Whereas, but what we don't find is something equivalent to subsection 6. But the way you read this is you say the amended version of, adapted version of subparagraph C does the same job.
That's right. It may be slightly less. It may be slightly less generous, but structurally, it's doing the same job.
But forgive me, there is a difference, isn't there? Because what we see in subsection 6 is an absolute exclusion as a matter of law of advertising rights, whereas on your analysis, what we find in Regulation 6 for C is dependent on factual analysis.
Yes, and on the tribunals
and questions of fact and degree.
Yes, and on the tribunal's analysis, what's happening by the addition of rights into the machinery of the railway is something that actually never becomes operative, because the question of whether the right should be included in the railway hereditament doesn't arise because of section 64.2, and that's what I say is the clear flaw in their analysis. So there are three possibilities. There's the more generous provision under the General Rate Act. There's this doesn't work because the rights are taken out at source, and there's my analysis in the middle ground, which is that schematically this is doing the same thing. Schematically you need to read them together, and schematically you need to apply your mind to the functional and control connection between the advertising and the railway. And that's not, I say, a radical proposition, because I say that's inherent anyway in the concept of an advertising right under the statutory provision because of the words let out. But my lords, just before the short German, my Lord Justice Nugee said it's all much clearer under the General Rate Act. That's true, but actually it's a little bit clearer if we go to the very first iteration of the Central List Regulations, which is the 1989 regulations. And may I try to do that very briefly before lunch, because the language is much tighter there, because it's pre-privatisation where lots of extra bits got added in. So that's at page 73 of the Bundle of Authorities. And that's the Central List Regulations 1989. Just very briefly, because it's all quite familiar shape, really, but you've got the designation of people in Regulation 2, the content in Regulation 3, and then the schedule is given effect to by Regulation 3, and the relevant part of the schedule.
Can you give me the page, please? I'm
So sorry. So
My
the
fault.
regulation starts at 62.
Thank you.
Sorry, that's the wrong reference. 73. Sorry,
73, my fault.
73.
Thank you.
And so shall I just, so you've got designation Regulation 2, contents Regulation 3, schedule, which is referenced in the content, is at page 76, part 4 of the schedule, railway hereditament. So the British Railway Board hereditament is hereditaments other than accepted hereditaments, used or mainly used for the purpose of the parts of the designated person's undertaking which are concerned with the carriage of goods or passengers by rail, or purposes ancillary to those purposes, including the purposes of exhibiting advertisements. So there's a very clear linkage with, so my submission is what's happened actually, when you look at this chronologically, is that the absolute carve-out from section 28.6 has been amalgamated into the railway purposes, and it's less absolute, but there is a clear line of succession between that carve-out and the definition of railway purposes. And then, if you look at accepted hereditament, the shape of that is exactly like section 32 of the General Rate Act, except for the point that I've said, which is the
It
rights.
sticks in premises or rights.
Exactly.
But what I've not understood is it your submission that the words ancillary to those purposes, including the purpose of exhibiting advertisements, means that for any advertising purpose is treated as a railway purpose? Like treated as ancillary to a purpose?
Yes.
Unless, and then, but if it was reproducing section 28.6 and just excluded the advertising regime from railway stations, then you wouldn't need the words rights in accepted hereditaments, but you accept that the purpose of putting in the word rights in little c in accepted hereditament is that there are some advertising rights which are to be rated separately.
Which may be, yes, depending on a contextual analysis of the extent of the control.
Well, if
Well,
you
the
ask
flank
which they are, it's those which are let out.
Yes, the flank wall is a good example. If there's a flank wall on the side of the railway and there's no operational impact on it, etc., that might be so let out as to be capable of separate assessments. But it's not ones that's bang in the middle of the station where there's an express power to intervene in it, and it's subject to controls which are subservient to the operation of the railway station. They are, I say, not let out so as to be capable of a
So
separate assessment.
this has to be read on a basis consistent with your interpretation of Regulation 6.4c.
Yeah, it does.
6.4c is the driver.
Forgive me, there are only.
But this paragraph, on that analysis, this paragraph doesn't supply the answer then.
But aren't there only, my submission is there are only two possibilities. One is that if the tribunal is right, that you never get into this, then this drafting was in error, because there's no, this serves no function if you don't get into this because it's not a heritage, the station is not occupied, or it requires an evaluative analysis. Now, of those two possibilities, one of them makes sense of the legislative history, makes sense of the need to read this in a joined up way, and the other one doesn't. My one is the one that makes sense, and the tribunal's is the one that doesn't.
I mean, your argument, I think you see this in your skeleton, your criticism of the other side's argument is that it doesn't allow for any advertising right to form part of the hereditament, railway hereditament.
Yeah, and also, I have many criticisms of that,
Well,
but also
that's the same point though.
but also that it rests on the proposition that there is some very significant difference between let out to someone other than the occupier and let out so as to be capable of separate assessments. And I say both of those are terminology that's directed at an evaluation of the extent of the connectional separation between two things, and that they're not fundamentally different expressions, but the valuation officer's case and the Upper Tribunal's analysis is based on the idea that they are fundamentally different things, and that doesn't make sense given the history that I just showed in the court. I accept that it's less generous than the General Rate Act. I don't accept that there's a statutory intention that you don't grapple with whether the rights are let out so as to be capable of separate assessment. But the whole of the reasoning of the Upper Tribunal was predicated on the proposition that that's not in play here. There's a much narrower concept, and that is, I submit, entirely discordant with the statutory history.
We need to come back to it, but at the moment I don't quite understand why adding the words as to be capable of separate assessment makes any difference, because if the rights are let out, then by definition they're advertising rights and they have to be assessed separately because they don't form any part of any other hereditament.
I agree with that. I agree with that, but I say that those concepts have embedded in them the need to evaluate the extent or otherwise of the separation, and the vice of the tribunal's approach, forgive me, is that it hung part of its reasoning on a significant differentiation between those two terms.
Could I just ask, not for an answer now, you've shown us, obviously you're placing emphasis on reg 6.4c.
Yes.
You've shown a sort of parallel in the 67 Act, section 32, 2c.
Yes.
Is that sort of provision to be found in the 1948 Act? I had a look and I couldn't find it in what we've got in the bundle.
The 1948 Act.
Local Government Act, which, because that deals with the definition of a railway hereditament in section 86.
I think it was in 19.
It is not, I'm not asking you to.
Because we've got the 1930 Act, which I was thinking I might go to, but I haven't. But,
Anyway,
let me see if I can help with that.
it may not matter, but whilst we're trying to assemble the bits of the jigsaw.
Is that a convenient moment? in
Yes, of
which
course
to
it is. I'm sorry.
break? How are you doing for time?
Well, I'm a little bit behind, I'm afraid.
Doing some heavy lifting though.
I mean, I'm in. I've nearly finished my. Well, I think I'll reflect. I think I've finished the history. I want to say a few things on the Upper Tribunal, and then there is some case law I want to go through, and then I've obviously covered a lot of ground in my submission. So I'm not sure whether the hour is a hard limit or whether I can possibly extend that for about an additional 20 minutes.
We'll have some discussions over the short
Oh,
adjournment,
thank
and
you.
if we need to resolve things, we will.
Of course, thank you so much.
Should we say 2 o'clock?
Thank you.
Court rise if able.